If there's a fly in your steak, you're not going to charge it with potatoes.
But sir, you started out with like a beaver or um, some large like badger type animal under there. Then when you came back the last time, we weren't talking rats. You were talking about mice and the baseboards being ground zero and all of that stuff.
Yeah.
Now I get here today and now these mice have grown and now they're rats.
Before this case even gets formally called, you can already feel the tension bubbling under the surface. What starts as a strange metaphor about a fly and a steak quickly turns into something much bigger, because this case isn't really about a single problem. It's about credibility, consistency, and whether a tenant's claims hold together under scrutiny. On one side, you have a landlord pursuing a non-payment case. On the other, a tenant alleging serious habitability issues, rodents, infestations, and what he believes is outright misconduct. And right away, you'll notice something important. The story keeps changing. We hear about beavers, then badgers, then mice, and now rats. In landlord-tenant law, consistency matters. Courts look closely at when complaints were raised, how they were documented, and whether the landlord was properly notified. This opening exchange sets the tone for everything that follows. Is this a case of a tenant being ignored while living in unsafe conditions, or a tenant scrambling to build a defense after falling behind on rent? Keep that question in mind, because Judge Simpson absolutely will. And as you watch, ask yourself, if you were in that courtroom, who would you believe right now, and why?
Court calls the case of Pleasant Lake Park versus Christopher Janoway.
Happy to see you, Judge. Happy to see you, Mr. Allen. I have documents to submit.
What? Oh, just
David Morris on behalf of Plaintiff Pleasant Lake Park, LLC.
thank you.
Thank you.
Your name, sir?
Christopher Genoviak.
Okay. And what documents are you trying to submit to the court?
A counterclaim.
This is our fourth hearing. Last hearing, plaintiff presented an inspection, an unsworn statement by an inspector, and Mr. Genowiak asked for 1 week to get his own inspection done. I understand that he has done that. He provided me a copy of an inspection report today, just before the hearing, and I understand from the Register of Actions that he filed a motion to set aside default, which maybe is the counterclaim. I'm not sure.
This is where procedure starts to matter more than emotion. The plaintiff's attorney is calmly explaining the procedural posture. Multiple hearings, an unsworn inspection, and now a last-minute inspection report handed over right before court. That timing is a red flag in many courtrooms. Judges expect filings to be timely so both sides can respond fairly. Dropping documents moments before a hearing puts the court and the opposing party in a tough position. It also weakens the credibility of the evidence, even if the claims themselves are serious. You'll also hear confusion about whether a motion, a counterclaim, or an escrow filing was properly submitted. This confusion isn't just frustrating, it's dangerous for a defendant. Courts run on paperwork. If something isn't filed correctly, it effectively doesn't exist. And Judge Simpson is already signaling that while he may be patient, he won't bend procedural rules just because someone is overwhelmed. So here's the engagement question. Should courts be more flexible with self-represented tenants who clearly don't understand the process, or does that undermine fairness to the other side?
I don't understand how I submitted the money. I don't know if I did that. I don't understand how I submitted money. I don't think I did that correctly.
How you what?
The money that you ordered to put in escrow,
Yes.
it's like a holding. Like, you may give me all the money back, hypothetically. I don't think I submitted the money correctly because I don't want to I put $12.30 in escrow because there's a $20.
You did.
Why are they putting this over here?
We also made him fill out this form. I don't know. That's why.
Oh, I see.
I told you about
Yes,
that.
you did.
Yeah, I think I did that.
No, the money, the escrow's there. We had a clerk that I don't know why they did this. What they did, counsel, is apparently the only way that they ever saw escrow come in without an understanding that I ordered escrow was on a motion to set aside.
I see.
And so they had to fill out that form, which really means nothing because there is no judgment had they looked.
Yeah, I'm ignorant of my actions. I don't know.
No, it truly, sir, there may be other things that are your fault. This one's not.
This is a subtle but critical moment. Judge Simpson is drawing a line between personal responsibility and court error. He's essentially saying, you may have made mistakes elsewhere, but the escrow confusion isn't on you. That matters, because escrow and habitability disputes is serious business. Courts often require tenants to deposit rent into escrow to show good faith while habitability issues are resolved. The fact that the money is there protects the tenant from immediate judgment, but only if everything else is done correctly. What you're seeing here is judicial restraint paired with clarity. The judge isn't scolding, he's correcting the record, but don't mistake kindness for leniency. Judges often give 1 or 2 procedural passes. After that, the consequences can be severe. And notice how the tenant still seems unsure of what happened. That lack of understanding becomes a recurring problem. If you were in this position, would you slow things down to get legal help or keep pushing forward, hoping the judge fills in the gaps?
So, well,
This
okay.
is, the
You
proof.
can hand it to me when I want you to hand it to me. You really do not have to bow. Okay. Have you seen the counter complaint?
No, I'm not aware of a filed counter complaint. And for the record, I haven't seen a copy of an answer, haven't seen any writings by the defendant.
Okay, so let me just back up a second. What did your report reveal?
It revealed conspiracy and perjury by the landlord, Mr. Weasel, and
Oh my gosh.
investigators.
No.
Oh,
You had an inspection.
Yes.
Or,
the inspection determined that there was a complete infestation
of what?
of rats. A complete infestation. There's rodents everywhere. Throughout the home in areas like the rotary room and wide open, and you shouldn't see, this is usually a sign of an infestation. The loose material underneath the dresser and behind the stove is from the rats trying to create a nest. The loose material behind the stove is from the stove's insulation, and be very.
Who's this from?
Here's where the case takes a dramatic turn. The tenant escalates from general complaints to allegations of a full-blown rat infestation, complete with technical descriptions and visual evidence. On paper, habitability claims like this are serious. Rodents can render a property legally uninhabitable. But courts don't just look at what's claimed, they look at how it's presented. Notice how quickly the narrative spirals into accusations of conspiracy, perjury, and conflicts of interest. Those are heavy allegations, and without clear, structured evidence, they can actually hurt a case. Judges expect facts, not conclusions. Photos help, inspections help, but only when they're properly authenticated and tied to legal claims. The tenant's emotional distress is real, but emotional testimony without procedural grounding often falls flat. Ask yourself, does this sound like someone methodically documenting a problem or someone overwhelmed and lashing out? That distinction matters more than most people realize.
It could be a fire hazard. This is from a company called Proof that has over 100 years. I have colored photos and I have to jump. It's licensed and insured.
Okay, just let me,
Would you like a copy?
thank you.
I gave the kind lawyer a copy of this. Sorry. I don't know if that's, did you give him what I gave you?
Yes.
Okay, so we have. Right, that is what I have. So the most, so the technician comments are, there are more pictures I did not.
Okay,
The
were these pictures a part of his report?
Yes, sir. Yes, Judge. This is,
Okay,
I haven't slept a single night since August. I called the police twice because I thought there was people outside my house, but it's really just a rat infestation. I've tried to get resolved and they wouldn't do walkarounds. So since August, I haven't.
called police on the rats?
This is the rats. Yes, there was more creatures. The whole house was just, there was holes in the skirting and there's proof. There's holes in it underneath the cabinets are connected to the wall. It's a complete rat hotel. I do it every night. They chew my property. This is a complete opposite of what this client said. His inspector is my next door neighbor. There's a conflict of interest in here. There's conspiracy, there's
Okay.
perjury. I might take this to trial to get them on record so I can later sue them.
This is where strategy enters the picture. The tenant openly talks about wanting a trial, not just to resolve the housing issue, but to get them on record and potentially sue later. That's a risky mindset in housing court. Judges are laser focused on the case in front of them. possession, rent, and habitability. When litigants start talking about future lawsuits, conspiracy theories, or criminal accusations, it often signals a lack of focus. Meanwhile, the plaintiff's side stays grounded. Non-payment, timeline, notice. Courts reward clarity. They punish chaos, not intentionally, but procedurally. If you're watching closely, you can see the power imbalance shift here. The tenant may feel morally right, but legal strength depends on precision. Engagement question: do you think passion helps or hurts in a courtroom like this?
Okay,
I might take this
all
one,
right,
get them on record.
okay, all right.
I might. You're judge.
Well, we welcome any trial if you would
I'm-
like to file an answer and a counter complaint. Your Honor, frankly, this is the first that plaintiff is hearing of rats. And this whole case it's on non-payment. For weeks or maybe months, the defendant has been complaining of a beaver or a badger under his premises. My client has been taking steps like trapping, poison, inspection under the premises, outside of the premises. We file a non-payment complaint, and the defendant still did not raise this issue. First hearing, second hearing.
Trust me, counsel, I remember everything
Thank you, Judge.
on this, and I just. What's in your counterclaim?
My counterclaim, Judge, has a photo evidence of a complete rat infestation, the complete opposite of what.
Okay, but is that the counterclaim?
I mean, this is enough for his client to be convicted of perjury and conspiracy.
I don't know what that means. I'm just asking, is that your counter complaint?
Yes, Judge.
Can I see that? And counsel, I'll let you take a look. I'm trying to. It's the report.
Yeah, that's mine. Yeah, this just proves everything that he's been saying the whole time. Because this is a licensed and insured rodent pest control with over 100 years of experience. And his rodent and pest control man lives on the same property that Mr. Weasel owns, which is a conflict of interest. And he's not licensed or insured. The inspector doesn't even own his own vehicle. He lives with his kind elderly father. And he used this.
Sir, do you understand that
I don't understand.
is not, it's clear that is not a counter complaint.
This may be the most important legal moment of the entire hearing. Judge Simpson states plainly, what the tenant keeps submitting is not a counter-complaint. This isn't semantics, it's foundational. A counter-complaint must respond paragraph by paragraph to the landlord's allegations and then assert independent legal claims. Photos and reports alone don't do that. Courts can't guess what relief you're asking for. Are you seeking repairs, rent abatement, damages? Without that structure, the court's hands are tied. The judge is effectively warning the tenant, you are standing on the edge of losing by default. And yet, the tenant still believes the evidence should speak for itself. Unfortunately, courts don't work that way. Evidence supports claims, it doesn't replace them. This is a hard lesson many self-represented litigants learn too late.
Should I put it in writing?
Well, that's usually where it starts.
Okay,
Yeah.
I know there's an order of operations and proper, ways of operating here. I thought this was sufficient for the court, that this is a professional who's licensed and insured with multiple lines contradicting the plaintiff's claims. And I want to make a deal. I want to leave. I feel like I'm being attacked.
You want to go?
My deal is, my proposed deal is not a serious one. I do want to go, but
I don't know what that means.
yeah,
What do you mean?
I would like to hear a deal. I could propose a deal, but I mean, I really want to stay here and get this rats out of my bedroom. It's literally in my bedroom. It's literally I have a stick just to poke the rats underneath the dresser. I literally have a rat stick next to my bed. For the record, I literally have a rat stick next to my bed for 5 months. So I could put this in writing. And I'm sorry to waste the court time. I've been trying to make a deal, but I tried to do a walk around and I tried to do a proper investigation months ago, but,
Okay, sir,
yes,
there are certain ways that you would have to do an answer and a counter complaint. Okay? And you need paragraph by paragraph laying out your allegations as against the plaintiff, as well as answering the plaintiff's claims in this case.
I
You
thought,
follow me?
no, I don't understand. I thought I did that when I first did the paperwork for the contract, like, it says like, how do you respond to the claims? And I was just like, yeah, I disagree with everything but like the money portion. So, I just thought this was like pretty cut and simple, like, if there's a fly in your steak, you're not gonna charge it with potatoes.
But sir, you started out with like a beaver or some large like badger type animal under there. Then when you came back the last time, we weren't talking rats, you were talking about mice and the baseboards being ground zero and all of that stuff.
Yeah,
Now I get here today and now these mice have grown and now they're rats.
oh yeah, the problem's gotten way worse, I agree with you, Judge. Problem's way worse now.
You're not really saying the mice grew into rats.
I'm saying that the rats have been there the whole time and that we haven't done a proper inspection. We haven't done it proper since the get.
All right,
Sir, Judge.
sir, go ahead.
It's plaintiff's position that to the extent this is a defense about habitability, that this is the tenant's willful and that the tenant has caused these through irresponsible conduct or lack of conduct. To the extent he has a rat stick or anything else, this is the first plaintiff is hearing of it. This should have
First I
been.
heard a rat stick.
Now the landlord's theory comes into full focus. Lack of notice. In habitability law, notice is everything. Landlords generally aren't liable for conditions they were never properly informed about. The plaintiff argues they were told about beavers or badgers, but never rats. That distinction matters legally, even if it sounds absurd. Different pests, different remedies. The mention of a rat stick is particularly damaging. It suggests the tenant knew about the problem but handled it privately instead of notifying management. Courts expect tenants to report issues, not self-manage infestations. This argument reframes the case from neglect to miscommunication, or worse, tenant-caused conditions. At this point, Judge Simpson is weighing two narratives: ongoing neglect versus unreliable reporting. Which one sounds more consistent to you?
This is to the extent the landlord should have trapped, should have baited, should have taken any steps, we needed to have been made aware. We were not made aware. It's clear to me that defendant has taken no meaningful steps to resolve the issue. His living conditions invite the issue, and that we can't be in a position, the landlord cannot be in a position to check in on the defendant to ensure that his quality of life is where maybe it should be. I submit to the court that there is no tribal issue here. To the extent the court disagrees or believes that there should be another chance to file something in writing, I think this needs to go to a trial, a short trial.
I want a bench judgment.
I'm sorry?
I want a bench trial, Judge.
Well, that's all you're entitled to at this point because I don't have a jury fee. So,
Correct.
so,
One other point for the record, Your Honor, is that management understands that, so there have been attempts to go out for the beaver or badger, and there have been attempts to assist with skirting and other various issues raised over the months. Management has been responsive, but understands that there was at some point, defendant in the last month or so made a comment to a neighbor saying that he would shoot management if they came and knocked on his door. He also claims that management has stolen hamburger off of his counter. So we're not sure if these allegations or threats are real, and we have to assume that they are. And this is part of management's concern, is that, frankly, that the situation has broken down.
This is where the case moves from messy to concerning. Allegations of threats, stolen food, and fear of approaching the property introduce safety considerations. Once safety enters the record, courts become extremely cautious. Even unproven allegations can justify stricter procedural enforcement or accelerated resolution. The plaintiff is painting a picture of a relationship that can't continue, legally or practically. This strengthens the push toward trial or possession. Meanwhile, the tenant appears increasingly lost in the process. This contrast, organized counsel versus confused self-representation, often dictates outcomes more than facts alone. It's not fair, but it's real.
And I think the trial would show that there were no attempts to bring management in on the rat, the mouse, or other issues other than the badger or beaver. And those have been proven or shown through the unsworn statement to be flatly false. Mr. Janowiak's inspector clearly did not see any signs of a badger or beaver either.
Hey, so how long is it going to take for you to put your complaints in writing to the court?
I don't understand what I should put,
Well, you're going to need to understand.
because I thought this was, so I'll put, so I know I'm not asking you for legal advice.
Good,
But I
I
need to
don't
just-
give it to you.
Right. So, and I this is quite the maze. And that's my ignorance. So I can put something in writing within 7 days, once I understand what to put, that's gonna be acceptable to the
All
court.
right, you're going to need to get to figure it out in the next 2 days. The defendant to file a written answer.
A written answer to what? A written answer
To the complaint.
to the complaint, and the complaint is what, Judge? I don't know, I don't understand what the complaint is.
All right, you got served with a complaint. That's what brought you here. You need to file an answer to that complaint. And if you got a complaint against the landlord, you need to file what's called a counter complaint, or your complaint against him. That you keep trying to hand me is not a complaint. It is not a counter complaint. It is nothing for the court at this point.
Judge Simpson is now crystal clear. Without a proper written answer and counter-complaint, the tenant will lose. Full stop. The deadline, service requirements, and consequences are laid out explicitly. This is due process in action. The court has given notice, opportunity, and instruction. If the tenant fails again, judgment will follow. This isn't about rats anymore. It's about compliance. Courts can't function without rules, and sympathy does not override procedure. This is the crossroads moment. Everything depends on what happens next, outside the courtroom.
I don't understand. So I will submit what so
You're to file a written answer and or counter complaint.
to the clerk.
You're to do that by December 3rd.
Yes, Judge.
Filing of that will only be complete once you file it with the court and you serve counsel with a copy,
I don't understand how to serve counsel.
usually by email.
I don't have proper access to email all the time. That's why there's like
Okay, get a stamp, put it in an envelope and send it to him.
gotta get it twice a year, basically. Judge.
No, you gotta, when you file it with the court, you have to serve them a copy because you have to acknowledge that you've given them a copy of what you're filing with the court. Then, so you're to do that by December 3rd. I will give you time to look at that. I'm going to go right to final settlement conference on it. And so I'm going to set a final settlement conference on this case, which is the step before we go to trial. Set that for December 9th, 2025 at 9 a.m. That is in person, and all parties must be present. Now, I'm going to let you know, I want you to understand this, sir. I have a lot of latitude if you don't follow the court's directions. So if you don't file an answer or a counter complaint, but if you don't submit something in writing in its proper form, I'm gonna grant them possession. I'm gonna grant them a judgment. I'm just gonna let you know that.
I will submit a written response. So,
Is, is there anything else?
no, Judge.
I have great trepidation to ask.
What, trepidation?
Never mind.
Could you define that?
Never mind. No,
I don't
I-
understand what trepidation.
I'm saying I didn't really want to ask you if there's anything else because I didn't want to hear anything else. All right, just to be blunt about that. But as a matter of courtesy, I have to make sure that everybody's been heard.
Yes, Judge.
Is there anything else?
No, Judge.
Sweet. Thank you. Everybody have a good holiday. Is this your only copy, counsel?
Yes, it is.
All right, so I'll. Court could stand in recess. I'll be right back, I swear.
All right.
Bye.
You may be seated.
This case is a powerful reminder of how courtroom outcomes are shaped as much by process as by substance. Judge Simpson did not rule on whether there are rats, mice, or any infestation at all. Instead, he focused on what the law requires: proper filings, clear notice, and structured claims. The tenant was given time, guidance, and warnings, but the burden now rests entirely on him to follow through. The landlord, meanwhile, maintained a consistent procedural narrative centered on non-payment and lack of notice. Whether this ends in trial or possession will depend on what happens next, not what's already been said. And that's the harsh truth of court. Justice favors preparation. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.